Well, our final panel is saying, if we assume that there's neutral principles that are going to be applied, you know, what does that look like? What do we look to? And you know, given the speakers whom I know, you know, they're probably going to go off in a lot of other directions as well. But that's at least part of the focus of this last panel. And the moderator of our panel himself could very easily have been one of our speakers, one of our good friends as well here at Pepperdine. Ed Larson is the Hugh and Hazel Darling Professor of Law and History here at Pepperdine. He holds a JD from Harvard and PhD from Wisconsin in history. He writes in the fields that are the subject of this conference, property, law, and religion. He's the author of a property case book. He's also the author of the Pulitzer Prize-winning book, Summer of the Gods, which was an account of the Scopes trial. Just last week, those of you who read the Wall Street Journal may have noticed that they had a column in which they're identifying they're identifying the 5 best of something or other. In this particular column, they had Alan Dershowitz identifying the 5 best books about a trial, and Alan Dershowitz identified Summer for the Gods as the #2 best book. In an earlier list,
did he say as one of his own was
Ed can tell us which was the best one if he chooses, or he can just leave you to go out and buy Summer for the Gods. In an earlier list of the best books, in this case the best books about a presidential campaign, the Wall Street Journal chose Ed's most recent book, A Magnificent Catastrophe, Tumultuous, it's been a long day, Election of 1800, among the 5 best books about election campaign. I can't remember, what was that, #2 also? #2 also. Always the what does it say? Always the bridegroom, never the bride, or whatever it was. Anyway.
That was by Carl Rove. That was the other one.
There you go. So Ed Larson to moderate our final panel.
Thank you. And first, I just want to thank Bob Cochran for putting this together. He so ably leads the Nootbaar Institute, and the Institute itself has been such an incredible asset to this university, and he deserves enormous credit. I do agree with him that Audrey does also deserve much of the credit, and if she's already left, I'm sure she knows it, but she deserves much credit. I also would like to mention Morgan Thrower, Margaret Barfield, and Patty Hayes, who also did quite a bit of work on this conference. So it's a team effort, and Bob is a crucial part of that team. So thank you very much, and thank you for inviting me to actually sit up front with 2 of these excellent speakers we have. Now, we have 2 speakers left, so they have a little more freedom on time. But we also thought this would be a good time to allow you to make more general questions. It is, in a way, it's the most focused of the topics, but in another way, it brings everything together, what these neutral principles would mean in practice. And so we should feel free, since we're most of the speakers are still here, to open up this at the end to more general questions that draw on these ideas. So this will give us a good closing opportunity as the end of this session. I find this entire conference, but especially this final panel, especially interesting because no matter how far back Bob goes on this topic, and he has worked on this topic and this issue for his professional career, and others of you go back, I was literally weaned on this issue. Because when I was quite young, when I was about 6, my father was elected prosecuting attorney for a county in Ohio, and after that he served as the they call it common pleas, but call it Superior Court judge for that county. And it seemed like we were a hotbed of this particular issue, of splintering churches and individual churches wanting to go their own way for the denomination. And he found these the most fascinating cases that he had. That, and we also had a lot of Amish people. And so he had, before Yoder, he had various different cases about whether the Amish were exempt from the ability to, the mandatory school attendance laws after 8th grade, and how it would be worked out before that. And so he spent quite a bit of time. And he had a philosophical turn of mind, so he was fascinated by these topics. They were the most interesting cases to him, and he used to talk about them at home, both when he was a prosecutor and as I got older, when he became a judge deciding them himself. And so I learned these issues very, very early, became involved with many of the churches, going down and experiencing, going with him and meeting with the churches, meeting with the congregations who were dealing with these issues. He used the hierarchy versus congregational approach, and I must say, as elected official in Ohio, both as a judge and a prosecuting attorney, that was the rule in Ohio, that you had to follow either hierarchy or congregational approach, and he did indeed manage to always find a congregational or Baptist form of government, even for African Methodist Episcopal churches, which conveniently always allowed him to rule on the side of his local voting constituency. But on high principle, he found very practical results. The highlight for me of all this occasion, and I wish I could bring more wisdom to this if I'd listened to him on this particular topic, but the highlight of all this is that one of our local ministers was a fellow named Joel King, and his nephew came in several times. He now has a holiday named after him. And he would come over to our house and discuss these issues. And so I got to know Martin Luther King through those encounters when I was quite young. And I know he was talking about these issues, but I don't remember him what he said. I remember him talking about other issues, but I know he must have had an opinion, because that's why he was up in town, because his uncle's church was going through some of these splinters. He was also talking about other things such as race, too, and equal rights. So this is an issue that I've followed for a long time, and it's indeed a privilege to hear that. I'm especially privileged to hear the two speakers we're going to have now. Shelley Saxer is one of my dearest colleagues. She went to this college here. She has her JD from UCLA, where she was managing editor of the UCLA Law Review. She clerked for one of the truly great federal district court judges in this state, Matthew Byrne. She worked with large private law firms, Melvin and Myers, at least that's the one I remember. Maybe some others. And she's been with the Pepperdine faculty for, about 15 years now? Most recent, 17, but who's counting? Most recently serving as our associate dean. She teaches in property law and community property, remedies, environmental law, land use. She's an extraordinary teacher, a productive scholar, an able administrator, and will bring, I'm sure, much practical insight on these topics. The last person we're having speak clearly should have been the first, our dean, who I can honestly say needs no introduction. He is, of course, was a clerk for the Chief Justice, Warren Burger. He's admitted to practice in California, Virginia, District of Columbia. He is known to argue, has been known to argue a few cases before the United States Supreme Court. 3 dozen at least, probably?
35.
Well.
But who's counting?
But who's counting? He was Solicitor General of the United States. He was a judge on the D.C. Circuit Court of Appeals, counselor to U.S. Attorney General William French Smith, one of the truly great attorney generals of our lifetime, a prolific writer, an extraordinary colleague, a magnificent dean, and someone who knows an enormous amount about everything dealing with law, but including these particular topics. So I will turn it over to the two of them, and then we'll have plenty of time for questions. Thank you.
Well, first I have to say that I liked the title of Bob's particular segment, Breaking Up is Hard to Leave to Whatever. I just remember Breaking Up is Hard to Do. And I actually saw Neil Sedaka 2 weeks ago. I went to see a new musical called Breaking Up is Hard to Do, and he was in the audience and got up and sang Love Will Keep Us Together. Not Breaking Up is Hard to Do, but Love Will Keep Us Together. So I titled my talk, Neutral Principles as Protection Against Earthly Sins. So we'll see how that turns out. In 1985, when Pastor Kingsley was first called to the First Baptist Church of Friendly in Prince George's County, Maryland, there were 127 members. By 2001, when the church voted to sell the church building, the vote was 16 in favor and 13 against. The church building was sold in 2002 to another local Baptist church for $900,000. Based on a majority vote, 16-6 this time, the proceeds were distributed as follows. $300,000, we start off with $900,000, $300,000 to a church savings account, $100,000 to the Jewish Awareness Ministries, $50,000 to the Kingdom Building Ministries, and almost $400,000 to pay off the mortgages on the homes of the pastor and his son, a church missionary. So this is getting down to where we really end up having to sell church property, which is the area that I'm interested in, not necessarily as much the fight between the local and the national denominations. Now, to continue with this case, this was a congregational church structure because the church had severed its connection with the D.C. Baptist Convention in 1999. Therefore, how do we resolve this in the court? What principles? Neutral principles? Well, we could resolve it by principles of government, right? What would we look to if it's principles of government? They're not a hierarchy, but majority vote, right? It's congregational. We can do principles of government and say majority vote here. That's all the court needs to look at. We had a majority, 16-6, distributed it. We're done. We shouldn't be asking any more questions. Give deference to the majority. The court, though, did look at what I would call neutral principles and said, let's send it back to the trial court to decide whether these mortgage disbursements were fair, whether they were reasonable, whether they were compensation. So let's look into this matter. We can do that. So neutral principles can be used to determine, as we've seen, the intent of the disputing parties. And there's several ways to approach this. We've talked about this. Professor Greenawalt wrote about this, said we can just look at the secular documents, we can go to the church documents, we can use combination, we can go to as much evidence as we can find. The New Hampshire Supreme Court, I think, suggests an interesting way to start this approach with neutral principles, which is to take a tiered approach. Start by looking at secular documents, and then, if we can't figure things out, then we're going to go ahead, start looking at the church documents, maybe expand that to other evidence. Now, I'm not going to cover this, but in the handout that should be in your packet, from looking at various cases, I tried to discern what are some of the documents that courts have looked at. And it's not just documents, they've looked at evidence that aren't in the form of documents. So I would point your attention to just on page 2 of that handout, if you can look at it later. But actually in one decision, the Concord Christian Center, the court looks at the actions of the parties to find that there's a subordination to the national church's hierarchy. So they look to the actions of the parties, past the documents, etc. Another thing that I would point your attention to is I copied some language from the website of the United Church of Christ, truly congregational, they come out of the congregational churches, where they make it very clear in their language that control over property and other governing functions belong to the church. And I want to know, Professor Greenawalt, did you consult with them at all to develop that language? All right.
But my father actually opposed the merger of the Congregational Evangelical Reformed Church because he thought that was going to make it too hierarchical.
Interesting, interesting. Okay, so I also tried to group, now we're talking about applying neutral principles. What are some of the categories of application? The first one is the one that we've been spending most of our time talking about today, which is where we have a local church that is breaking away from a national or general church, the main denomination. Now, Dean Starr is going to talk about this after me, and he's going to also make some predictions as to how this is going to move. So we'll get back to what I would say is probably the area of most interest right now. But I wanted to try to pull it away from the issues that I think are causing us difficulty when we're dealing with issues about recognition of gays in the clergy or gay marriage, and just see how neutral principles are applied in other cases. So you have the breakaway situation, but I'm not going to focus on breakaways having to do with doctrinal, ecclesiastical issues, but more issues of governance. So that's the first scenario. The second is where you actually end up finally closing the church's doors. And if you don't have a hierarchy, the question is, what do you do with the money? I think that's a very interesting question, and one that I was involved with a schism in a church that I was worried, frankly, about what was going to happen if a majority or if a particular group became the majority and voted what they might do with some very valuable property and how they would disperse the proceeds to that. So that's not too many cases I could find about that, except for certainly the one that I read to you. Now, the third, I think, is interesting, and it's probably more common, and those are internal schisms that Ed talked about. Internal schisms within congregations, or even those, again, between the local congregation and the national, dealing with strictly governance issues. And what I think we have happening there are just bad actors. They're bad actions, that's why I titled it Earthly Sins, but we have individuals who are acting badly in some way or the other. We feel that they're stealing money, we feel that they are overreaching. And so can a court come in and use neutral principles to try to deal with those bad actions that generate these schisms, apart from doctrinal disagreements? So the premise of this is to say neutral principles we have to have. That it's important in order to help these organizations continue to function, and at some points they're going to need to come to the courts over issues that are not doctrinal but issues that they need help with. Now, I'll note that some courts have refused to apply neutral principles to anything other than cases involving property disputes. So they just say, doesn't work, we're not going to get involved, this isn't a property dispute. But other courts have applied it to non-property disputes, internal governance. Now I'm just going to give a few examples of this and how it worked. These are actual cases and applications of that, and then I'll conclude quickly and make a couple of observations about things that have already been said here today. First, let's look at the situation where we have a dispute between a local and a national church, and it appears that the national church is the bad actor. Now, that's a normative judgment on my part. But there was a case out of the 8th Circuit in 1995, and it's a Church of God in Christ case out of Missouri. The local church was required to title its property in trust for the large religious organization located in Tennessee. But the local church never agreed to do this. They didn't acknowledge oversight by the National Church of God Church. The National Church then revoked the pastor's credentials and tried to remove him from the local pulpit and filed suit to get him to vacate and reform the documents to reflect the National Church's interest in the local property. The Eighth Circuit, I think, did find overreaching here on the part of the National Church and applied neutral principles, said there's no state statutes, looked at the fact that the National Church didn't contribute anything to the acquisition of the property. The local congregation exercised complete control over the property without interference. The local church's articles of incorporation explicitly declared its independence. The language of its deeds vested title and control over the property in the name of the local church. The National Church had a charter and a constitution, but the court also looked at the fact that the National Church never provided that to either the minister or any of the members of the church. So we had a notice problem there as well. So there was no proof that the local church acquiesced in the National Church's charter. Now, you could say there's some hierarchy involved here, but applying neutral principles, we did not defer to the National Church, and the court found that the National Church's actions were, in trying to remove the local pastor, were outside the scope of its control, so no effect was given to it. So here we have the courts coming in. It's a governance issue. We're finding maybe some overreaching on the part of the National Church, and the court saying, no, you can't do that. We're not letting you have jurisdiction over the local church. Now we have another situation, again, dispute between local and National Church, but here the local church appears to be the bad actor. This is a New Jersey case, 2006. It's unpublished, though. The local church was formed in 1995. It adopted the bylaws of the National Church. They then purchased property in 2002. They needed to have an individual purchase the property who then agreed to hold the property in trust for the benefit of the National Church. Well, the local church decides they want to get out of this. So they try to get out, and the court looks at the documents, and in fact, we have minutes, which is another type of document that can be looked at, church minutes. False documents were submitted by the local church to the court. They had backdated the minutes, showing an adoption of new bylaws in 1997. Now, of course, they didn't purchase the property until 2002, but they talked about the purchased property in the 1997 minutes. So, and on the second page of the minutes, they left the 2002 date on there. So it wasn't too difficult for the judge to find that they were trying to backdate the minutes. The court looked at these minutes, looked at what happened. Although there was testimony that the local church didn't receive any funding from the National Church, the court reversed a dismissal of the complaint because the complaint had been dismissed. Sorry, we can't decide it. It's church doctrine, which a lot of courts still do. Ecclesiastical, we're just going to dismiss the complaint. Well, the court reversed that, and it said, you need to go back and decide whether to subject the local church to the National Church bylaws, which required arbitration at least. So we do have there a local church acting badly under the governance structure, courts needing to come in. All right, let's look just at two more cases. Internal schism, not involving a national church. And we have the court applying neutral principles to address bad acts. I found an example of not a Christian church. Well, I guess it could be a Christian church. I'm not familiar with the Baha'i religion, but we have a Baha'i church in Montana of 2005. And the schism is over who is the guardian of the faith. And the guardian of the faith is the leader who is of the Baha'i church, who is also considered to be the corporate president. So we have a mixture of corporate law coming in with the determination of who's the leader. And there were claims by other people in the Baha'i group that Chase had converted corporate property. So we have property here at issue. And the court said, well, our only role is to resolve the controversy of membership and to determine who makes up the board. So we need to go back and also look at corporations law. What is the power of the presidency? How can the president of this corporation, once we determine who it's supposed to be, how can they control the property? So looking to neutral principles to resolve this schism. We have concern about bad acts of conversion of property. And so we look at corporate powers. We've got to look at the corporate articles, the bylaws, and any pertinent resolutions to resolve that internal schism. Finally, another internal schism involving a Church of Christ in Indiana, 2000. The trustees terminate the minister. So we have the group of trustees terminating the minister. The congregation then votes not to recognize the trustees as the church leaders. This also happened right before the church incorporated and right after the congregation voted to purchase new property. So we've got some difficult issues here. Now, Indiana recognizes that this is a congregational church, and so we're going to look to the majority members for the representation. I would say that that's a principles of government approach to this, is to say the majority is going to control. And I think that's the way they decided it. They didn't look too closely into this. They just said, here, the trustees were in the minority, and the incorporated church was the majority. The court had no need to get involved with ecclesiastical affairs, and it can resolve this based upon majority. So there was no, it looked at the trial court decision and said there's no error in finding that the property belonged to the incorporated church, not the trustees. Now that seems to me to be a principles of government approach, because we're going with who's in the majority, that's it. So I think neutral principles is the better way to go to try to help churches that are communities, they are organizations that sometimes have bad acts occurring, and we need to use neutral principles for that purpose, instead of deferring either to hierarchical decisions under the principles of government or blindly accepting a majority vote under the principles of government approach. Now, I would like to add a couple of more observations from today before I sit down and let Dean Starr take over here. The first comes out of panel 1, and actually Professor Greenawalt's address to us. I think there are two ways to look at neutral principles. And there was some conflict over what do we do about the Smith case, which the Smith case applies neutral principles. And so are those two situations the same? Because I don't agree with the Smith case, and I like the fact that our LUPA came in to take a more searching look and not to have a neutral view of this. But I think that the neutral principle is great as applied to these property dispute cases. So what's the difference? I think there's a big difference in that using neutral principles in the church property dispute cases are dealing with things happening inside the church. It's individuals acting within the church body, and we need to resolve that dispute, and so we can use these neutral principles to do that. And we also want to use those neutral principles when we deal with issues looking on the inside from the outside, and I'm thinking of currently Cardinal Mahoney and the fact that we're viewing potential bad acts with internal between Cardinal Mahoney and others and the individuals, fraud action. Those are all internal issues that we are taking jurisdiction over to look at, and we'll see how that proceeds. So I think that is looking within. Smith neutral principles and using our LUPA, there I don't think neutrality is sufficient, because what we're trying to do is to protect religions and religious institutions from the outside, from government abuse. That's not what's happening in the property cases. We're not talking about government abuse there. We're talking about trying to resolve individual bad acts. So I think that the neutrality principle in Smith is very different, because there I don't think it is sufficient to protect against government abuse, and I think we need things like our LUPA to do that. From Professor Cochran, the idea of communitarian ideals of the individual, and I would add to that Professor Brownstein, individual autonomy, and taking it back to the idea of property, and Mr. Johnson brought us back to the idea of property. Individual autonomy, what does property mean? And I would say to fellow property professors out there, we know that property is everything, right? That's what we tell our students. Property governs it all. And so the idea of property that you hold, the personal nature of that, your connection to that in a church, to those silver chalices that you're polishing and now the national church is going to take away from you. That's individual autonomy, and property is about expectations. And I think property expectations come from the individual autonomy. So it's very difficult to think about giving that up to the hierarchy without your expectations being changed. So I'll stop there. Thank you.
Let me add my word of thanks to Bob Cochran for his stellar work in organizing this, and to say what a joy it is to be with my two friends and colleagues, Professor Larson and Professor Saxer. We gather really in the wake, as it turns out, and has been noted more than once, of the California Supreme Court's potentially landmark decision on January the 5th, which has really brought into sharp relief what we've been talking about. Neutral principles versus, however one wants to describe it, hierarchical deference, but deference to the governing polity. And we've heard today, the very first panel this morning, with this sweeping panoramic view of the condition of religious liberty in the United States, as well as religion clauses jurisprudence. Kent's wonderful address, bringing us through the jurisprudence, and then his own very well thought out and beautifully articulated vision. Then the very moving presentations, the boots on the ground, from someone who has been part of the decision-making process of a connectional, hierarchical church, and then someone who feels as if her church has left her. As Ronald Reagan said, I didn't leave the Democratic Party. Someone said that to me today as a reminder. That sometimes you feel as if you've been betrayed by the organization that you joined once upon a time. These cries of the heart that we heard just before lunch, and then the very skillful panel this afternoon, the communitarian ideal, can't we start bowling together again? And then the two brilliant lawyers, Jeremy and Steffen, giving us as judges, well, these are pretty strong arguments on both sides. The news I bring you is, of course, the courts are likewise struggling. In fact, there is just a complete, I'm so grateful for Professor Saxer's observations, because she's brought a lot greater clarity than you do by reading a lot of these cases. The courts really are struggling. That's not meant as a criticism, it's just a reality. They just don't know. What do we do with this? Yes, neutral principles, quote unquote, are in the ascendancy. Our own wonderful student, who's now clerking in the Virginia Supreme Court, last year as a student note or comment in our own review, did a marvelous an encyclopedic examination of the case law. And Jeff Hassler came up with, guess what? Neutral principles wins the Derby. But guess what? Within that tent of neutral principles, there are all kinds of variations on the theme. And there are some who've expressed the view that all the California Supreme Court did was to say, we, of course, embrace neutral principles and then slip in hierarchical deference through the back door. And some would say many courts are doing that, causing many to throw up their arms and say, you know, we need guidance. Yes, this is ultimately a property law dispute and perhaps a corporate law dispute and law of trust disputes, but there is this enormous overlay of fundamental freedoms protected by the religion clauses. And it's as if courts, if you go too far here, you're on a slippery slope and you're into establishment or non-establishment clause territory and dangers. And then, whoops, careful, free exercise clause values are very, very important. What's an honest judge to do? Well, we now know your father would say, be principled, but vote in favor of your constituency. But that, of course, shows the virtues and perhaps the non-virtues of an elected judiciary. What about drawing from Hamilton's Article 78, Federalist 78, and Article 3 of the Constitution? What is an independent judge in the federal system supposed to do, assuming you get the issue up there? Well, I want to come back as we keep talking about the case, ironically, happy anniversary, happy 30th anniversary, because just this month, 30 years ago, Jones v. Wolf was argued and then decided on the 2nd of July. Do you know how frosted the justices are if they're not out? You remember Justice Harlan must have wanted to be out before July the 1st. I remember very famously Justice Brennan had his reservations on the Nantucket Ferry on June the 30th. If you want to keep going, Chief, into July, you're on your own, but here's my dissent, as the case may be. July the 2nd, Jones v. Wolf comes down. Now, we keep saying, well, it was very interesting in the majority and then in the minority and so forth. I want to drill into that just for a moment. Then I want to try to transport the fault lines from Jones v. Wolf from 1979 to the current court and hazard a guess as to whether is neutral principles going to win, or will the court go in a different direction somewhere in between, neutral principles plus, neutral principles with teeth, hierarchical deference. The majority opinion in Jones, and we've had a great lawyerly exchange between Steffen and Jeremy with respect to parsing it, and then we've had Judge Cochran, or Justice Cochran, say, let's read it context. Let's rise above it. Let's give credit to where credit is due. Jones v. Wolf is said to embrace neutral principles. So let's just say that's its fundamental baseline. That was authored by Justice Blackmun. He had only 4 votes with him because there were 4 dissenters. The dissenters, and this has been noted, who embraced hierarchical deference were Justice Lewis Powell, writing the opinion, which has been quoted from today, Justice Potter Stewart, Justice White, Chief Justice Berger. Students of the court will, and Kent, of course, has the singular benefit of having clerked for Justice Harlan, and not so terribly before this time when the court was struggling in 1979 with this case. What that tells me, with one important exception, is the center right of the court was saying, hands off courts. We are not going to interfere with a connectional hierarchical church's determination. Period. In fact, we think it's unconstitutional for the court to be suggesting otherwise. Now, interestingly enough, Justice Blackmun has a somewhat Hamlet-like quality in his opinion because he says, now, neutral principles is consider this a jurisprudential cafeteria. we kind of think neutral principles is rather nice, and we're going to sell you on that, but we don't want to be pushy. Maybe there's some other way that you would like, you choose. You can say, gee, isn't that nice? It's very Jeffersonian and pro-federalism, and Brandeis's Laboratory of the States was lifted up, and so forth. So it wasn't exactly a robust neutral principles. To get that, you need to go back to Greenawalt's watershed article saying you cannot have this divided house. You must choose, and indeed you can only constitutionally choose one. Neutral principles. Go to that wonderful piece in the Columbia Law Review, or better yet, Kent, buy your 2-volume work.
Don't tell them that this stuff is only in one of the 2 volumes.
Oh, but buy both and then hunt. Seek and ye shall find. In the silent majority, not concurring, was Justice Rehnquist. Wait, why isn't he over with Justice White and Justice Stewart and Justice Powell? Why is he over with, is that Brennan? Is that Marshall? Blackmun? Steve? What's he doing over there? Good question. If you scroll back to the Serbian Orthodox case, you will see that the late Chief Justice, but then Justice Rehnquist, was in dissent, suggesting that Justice Brennan was being much too deferential to the hierarchy of the Serbian Orthodox Church, and he put, what shall I say, his finger on what Dean Saxer, Professor Saxer, has called bad acts. If we don't look at what this hierarchical organization has done, we may become handmaidens of lawlessness, or words to that effect, right? Handmaidens of lawlessness. It's not that whatever, remember Lola in Damn Yankees, whatever Lola wants, Lola gets. It's not just what they want in Belgrade. We're going to drill into that, and we're going to take a close look. And guess who joined Justice Rehnquist in that searching look at what the Serbian Orthodox Church had done? Justice John Paul Stevens, the only remaining member of the court from the 1970s. So let's predict. Got your Ouija, no, not the Ouija board. What do you call it? Crystal ball. Got your crystal balls out. There are 2 things that I would suggest about the current court, which of course has not had occasion to deal with this. 1, it is deeply skeptical of judicial power, cutting across ideological lines, with a few exceptions, especially protecting autonomy values. We see this, I could quickly rattle off, civil litigation. All 9 justices, very skeptical about complex civil litigation. Reluctance to constitutionalize particular areas of the law, CEG, end-of-life issues, with Justices Breyer and Ginsburg likewise saying, you know, we're just not going to go down the Roe versus Wade court, not in those terms. We're going to what? Allow the democratic conversation to go on. Justice Scalia, of course, gave us famously the much maligned, and it's been maligned again by Professor Saxer, opinion in Oregon Department of whatever employment versus Smith. This absolute, let's leave the field, and life is tough. If it's a general, neutral, applicable law, you see where we're going, don't you? You joined that church. You assumed the bloody risk. Life is tough. Don't expect judges to come bailing you out, no matter how much anguish you may feel. You said, gee, that sounds so harsh. What about bad acts? Case selection. if you put before the Supreme Court of the United States, which wants to leave the field, to minimize the role, name those great cases of the 1950s, of the 1960s, when I say great, I mean large, of the 1970s, and then start naming the great large cases of the 80s and the 90s and of this century, the court wants to leave the field and to keep First Amendment values, the democratic conversation, Professor McDonald, going, being quite rigorous and vigorous in that. But what if the court is presented with a genuine bad acts at the mother church, terribly offensive behavior that causes a suggestion of corruption or questionable activity? Then it might very well be that this court would look more holistically in, shall I say, a direction that Justice Kennedy enjoys driving the court. In other words, this case will be decided 5-4. However, Justice Kennedy decides, and that, of course, depends on how strong the record is. Thank you very much.
We have ample time for questions. Questions can be directed to this panel, but they can be, as I say, focused on what was specifically discussed. But as you already gathered from their participation in the conference and their comments, both of these panelists are willing to take on any of the topics that have come up today. So we'll start with Mark.
Is that microphone still dead?
Yeah, no, it's on.
Just a comment on a Baptist church that became congregational because it split with the Baptist Conference. They should have been congregational already, but that sort of continues to show how difficult these divisions are. Just because they're part of a Baptist conference shouldn't make them part of a hierarchical church. And then I have this question. What about single congregation hierarchical churches? What I mean by that is all these churches, it's a single church, they got a bishop. And it seems like within their single congregation, they've set up people who run the show. Are we still going to have majority rule? Or can a single congregation make itself hierarchical?
I'm going to turn that first over to Shelley, but you raise a very important issue that we tend to be focused on the Episcopal Church and individual churches wanting to leave a larger denomination. But there's this constant, as I found out as a boy, there's this constant stream of cases where you have a pastor battling with a changed, possibly majority in their own church, or a dispute between the board and the pastor, and the documents, such as there are, might give total power to the minister, as opposed to by a congregational vote that you capture that with bishop. And sometimes you get cases in property dispute where the deed to the church is given to the church in the name of the particular minister too. Or it may be, or the property may be held in the minister's name. So those sort of issues develop, and I will start off by turning it over to Professor Saxer, and then we'll add anything that Dean Starr wishes to add.
Okay. I think this is what I'm struggling with in the way that we just approach the structure of our analysis, because I'm not sure it really matters as much whether you say that the church is hierarchical or it's congregational. I think what you need to do is take the principles of government, and if you're going to decide it based upon whoever is governing, and that might be clear. If it is clear, and it might be with a hierarchical church, then you go with that principle of government. If you get to the single congregation and you have clear documents that say it's a majority vote of the congregation, you can use principles of government to say majority vote. If you don't have it, then that's where I think neutral principles, and even with the majority vote, it might not be clear how that majority vote comes about. How much notice was there given? What do the documents say about notice? What are the practices? Because some of the churches that have been in this litigation have no documents and have nothing written. And so then you have to look at practices. That's why I think neutral principles is the best way to go, because it helps us look at any type of abuse, whether it's at the single congregation or the hierarchical, to see, and I can't remember who else talked about governing, maybe it was you, Professor Greenawalt, talking about the governing, which is so important, and we need to help churches with that when they get into a dispute.
I would just add, quoting from the dissent, the Justice, then Justice Rehnquist's dissent in Serbian Eastern Orthodox, because I think the answer is contained here. For as the court in Watson, so pre-Erie, general common law observed, this is sort of general neutral applicability. Religious organizations come before us in the same attitude as other voluntary associations for benevolent or charitable purposes, and their rights of property or of contract are equally under the protection of the law. So I think the caveat, the Establishment Clause and perhaps Free Exercise Clause caveat is, but thou shalt not begin engaging in what is the true church and so forth. Avoid all interpretations of doctrine. But as long as you set that aside as best you can, but it seems to me from what he writes, and I'd be very interested in my much more informed colleagues' views on this. It's one opinion, so let's don't get too carried away with it, but it does seem to me that Justice Rehnquist was willing to, in his dissent here, to say, I'm willing to look at all these documents. Look, I'm a judge. I go to church. I can figure this out. So I'm going to look at these governance organizational documents, and I'm going to read and determine whether there was procedural regularity and so forth, because otherwise you're doing what? You're discriminating against, or you're somehow sort of not preferring. You're just saying, we exclude you from the civil court system because you chose to join what you knew to be a hierarchical organization, so we're not going to give you comfort and succor. That doesn't seem quite right, doesn't it? Seems like a reverse form of, it's anti-preferentialism.
And as you noted, often those issues that can be captured in documents are doctrinal in nature, that by their very nature of their church, their doctrine emphasizes, say, discipleship or being under the authority or a particular role for the minister who might call himself a bishop, apostolic, and yet it's an individual church. And those are the groups that often raise a lot of money and have built a big church, and then there's a large schism within the church. And it might be a majority schism. And does it go with the minister? And many of these questions blur their documents, which are often incomplete and sometimes self-serving. There may be multiple meetings with decisions being made different ways, and there could well be, it could well pull on very doctrinal matters, and I certainly defer to the dean that Justice Rehnquist would have been willing to look at all that, and he would have done it with a brilliant mind and with great curiosity. There.
Maybe I can.
Well, it's best to use it.
Yeah, Jim and then Jeremy.
And then right behind you after.
Oh, were you calling?
No, I was calling on you.
All right, fine. A very practical question. It's all over the lot. We've heard that today. What kind of case would you like to see go to the Supreme Court at this point to clarify things? And do you have any guesses as to which one might go? My assumption is that it would come out of one of the hierarchical churches, because that's where the political push is and the money is. And so what's your looking ahead? As you say, it's been 30 years.
Let me refer that first to Dean Starr and then to Professor Saxer.
Well, I guess if I had my druthers, it would be one first with a very elaborate record. You may not be able to get one. A lot of these cases, including the California political cases do not have much of a record at this stage, just given the procedural posture. But for example, first of all, I'm a religious liberty guy. That means what maximizes religious liberty on the part of whom? And I would say here and now. I understand the anguish when you're talking about the First Presbyterian Church of Schenectady in 1789. I mean, that is very powerful, very, very powerful. But we do live, and this is in this communitarian insight that I think Bob brought, in a very anti-hierarchical world. We like the autonomy model and people being able to find their own way and so forth. So I would tend to think that if you had a mother church, as it were, that seems so clearly to have departed from, and I'll use Kent's example. You used, I think, in your wonderful law review article, thou shalt not have female clergy. We can determine that. We don't have to get into a big theological dispute about whether that's wise or not, but you've now ordained women. You didn't used to, and you didn't for 2,000 years, but now you do. That's a departure. That's pretty darn significant. I think Rehnquist, and if Rehnquist's spirit lives on in the court, I think the Mother Church has a real problem. You have chosen to depart. I mean, it's obviously will stir up some controversy. You have chosen to depart from literally centuries of tradition. So don't be surprised then when people say it's time for individual autonomy. You've left us. We didn't leave you. And then the other example that you use, but again, was kind of a very clear cut that you could make this kind of seemingly doctrinal.
In the context of an express trust.
Oh, an express trust.
No, I think it's a little harder because if it's a tradition, of course, the whole culture's changed or more toward the equality of women, and it's a little hard. Yeah, anyway.
Yeah. So, but I think that. Right now, the court tends to be a liberty is the baseline, except we're very skeptical about judges being on the frontiers and pushing that and so forth. So the best from the perspective of religious liberty would be not from the Presbyterian or the Episcopal, but the hierarchical church that had really become, and I mean this, corrupt in a much more sort of almost bad acts kind of way, as opposed to truly theological or doctrinal disputes.
Yes, just a quick observation and then a question. One, to sort of pick up on sort of some of Shelley's discussions, one of the reasons that courts may not want to get involved in sort of even in the bad acts consequences, it might come out of sort of the famous Harvard Law Review article from the early 1900s talking about general private associations where they referred to the governance as the dismal swamp, and that has sort of been taken through 100+ years of cases just in the non-religious private association context where courts are very apt to defer to the decisions made by the hierarchy and not look in to see sort of how the sausage is made, so to speak. And so that may be sort of the reluctance of courts to get involved. But I did have a question to the panel is why do you think it's been so long since the Supreme Court has taken a case in this area? There have been literally hundreds of cases across the country applying Jones versus Wolf, and yet none of them seem to have gone up to this point. I was wondering if anyone had any theories as to that.
Maybe it's because we're a church and we're a family and people aren't that interested in airing dirty laundry, so there hasn't been a push. Maybe we just want to resolve this with us. That's just a guess. I just don't know that I've heard that much about it, even being involved in a church dispute. That I even knew that there were rules about this and issues because it just didn't come to our attention.
I'll add one thing, and then I'll turn it over to the dean for the correct answer. And that is that this is as one person described it, as a swamp. And I think for very practical reasons, churches are like families. They're constantly battling. There's tensions, and if they thought that they could go to the courts and try to settle it, people would be doing it all the time. And I don't think judges want to get in that situation, just like they don't like resolving family disputes. Police don't like coming to the scene and resolving a family dispute between spouses. Judges don't want, I don't believe, want to be put. Now, there's certain times when they know they have to be, but, and especially when it's a single church. Which is really, so many of these are really not between the denomination and the individual. We forget most of them are within an individual church. And if the parties thought they could go off to the courts, and the courts would get caught in this mess of trying to unravel this thing when there's plenty of wrong to go around. It's just like a divorce. Usually there's plenty of reasons on both sides and having to decide it. And I think this is the same situation. The judges just don't like to get into this situation. So I think that's been a factor. And knowing that if the Supreme Court started issuing decisions on this area, that would mean the lower courts would suddenly get caught into this, this mire. And now on to the dean.
Rule 10 of the Supreme Court rules, as Professor McDonald and others know, talks about importance. I'm not sure that the court, this echoes what Professor Saxer said, believes that this is a burning issue. Conferences like this, people talking about it at judicial conferences, at American Association of Law Schools gatherings, sort of puts it on the radar. Secondly, remember, these are typically coming out of state court systems with rich interpretations of state law, and that tends to create vehicle issues. Is this constitutional issue very cleanly presented? And for further commentary, I would defer to Steffen and his colleagues at Winston and Strawn, who probably think about this, and Jeremy at Horvitz and Levy, who probably think about this as much as anyone. May I turn the table
please
back to Steffen and Jeremy?
Microphone.
And then then we come back for your question.
I apologize. But
No, that's fine. No, good idea.
I don't have a lot to add to that analysis. I think it's good analysis. Ed's point that these are family disputes and courts kind of like to avoid getting involved, I think that's a common sense instinct. I think about if you look at the Supreme Court's decision in cases like Lopez and Morrison, where they seem to want to set some limit on the commerce power of the Congress. One reading of those cases is that, you know, the court's saying, you know, Congress can do some pretty bad stuff, but we don't want to see domestic disputes coming into the federal courts based on congressional legislation. We want that to remain an issue of state law. And I think, you know, these cases are very often messy, factually messy. You know, equities on both sides, and experienced practitioners know how to use that to keep a case out of the Supreme Court if they can. I do think Dean Starr's point about Rule 10, and particularly, you know, most of these cases come out of state Supreme Courts, which they should, because they have the ability to interpret state law and to change it based from past precedents. So then you have finality issues. You know, the Supreme Court, with limited exceptions, can't take up state Supreme Court decisions unless they're final. There are some exceptions, but again, it has to be a clean issue. It has to be the sort of thing that people say, even though it's not technically final, it'll resolve the case. And so they have a lot of excuses. But you know, obviously, it's been 30 years, and there are a number of cases brewing, so that may change.
I think I agree with everything that's been said. The only point I would add, and I know that there's at least one person who will probably disagree with me because we got into this somewhat at the end of our last panel, which is my belief that the hundreds or so of opinions that have come out since Jones in the various state courts around the country have all been, I think, relatively consistent in applying Jones and in their interpretation of that paragraph that is probably somewhat inartfully worded, but they all seem to be coming to more or less the same conclusion as to what it means, and so there hasn't been a conflict upon which the U.S. Supreme Court would deem worthy to take a case to resolve that split.
Yeah, and yet the hierarchical church doesn't always win, but that's part of the messiness of it.
No, we had a question. Back there.
Actually, while the mic's being passed back that way, I'll ask a question. Oh, no, it's already there. Go ahead.
Go ahead, Bob.
This may be sort of a heretical question to even be asking, but I'll ask it of Dean Starr. To what extent might the religious background of the justices themselves affect the way they would resolve this case? I mean, as I was speaking and as I've addressed this issue, having been raised in a Baptist minister's home, having had it preached to me, from day one, the importance of congregational rule. We're not like those, churches that have bishops that tell, people what to do. I mean, to me, the answer was obvious, particularly when you've got, free exercise arguments either way, establishment issues either way. Jim Miller mentioned that they first took their case before a Catholic judge, and I think he sort of implied that, well, of course, a Catholic judge would view these in hierarchical terms. I'm just wondering whether the fact that we now have 5 Catholic justices might lead them generally to think in terms of, well, of course you defer to the hierarchy.
One of the first commandments of advocacy is thou shalt not psychoanalyze a sitting justice. I would simply then respond by looking back to the conversation in these earlier cases. You have to go back a long time. But Justice Brennan seemed to be, in the Serbian case, pretty gung-ho, hierarchical authorities. They have spoken, etc. We're not going to intrude into this. And then you had Justice White, from the Rocky Mountains, independent judgment kind of person, saying and using those terms. He concurred, but he still said, hey, we have to use our independent judgment here. And then devout Lutheran, Barry, right, sung in the choir. Bill Rehnquist, good tenor. John Paul Stevens, who I think has lapsed from the choir of his boyhood, very much in a, hey, we want to find out what's going on here. And we're concerned about what Professor Saxer called bad acts. We don't like bad acts. So will there be a little bit of a moralistic, who's good and who's bad in this drama? And that could then, it seems to me, convince a, quote, hierarchical worldview person, this is really bad. And I'm not necessarily going to not engage in my independent judgment and to look at the documents and so forth.
Question there, and we'll have time for one more because we are reaching the 5 o'clock hour. Yes.
I'll speak concisely, I hope. I don't know if this comment is material or even relevant, but I do try to get enriched from the historical perspective. And I note that we have a fairly long history on our Anglo-American common law of not according property rights to unincorporated associations, which is a way to describe early church congregations. And even corporations were reluctantly granted property rights. Only late in our history, the statutes of Mortmain tended to proscribe that because those were mostly charitable contributions when property went out of productive use. So I think the history tells us that property rights held by religious denominations at first were those accorded by the respective sovereigns over those denominations. We have a long history then of defining congregational or hierarchical property rights by acts of government. And that's all I intend to say about that.
Well, true, and if you look back, if you want to go back far enough in the Middle Ages, the only other person who could own property besides the king was the church. That was the only other people who had it, but still, church, as was been noted, sometimes kings took it away.
But didn't we have a Reformation?
But that was well, even after the Reformation, the kings wanted to keep it. But those were the only people who had it. So it's an interesting. But those were very hierarchical churches. And for our last question, excuse me.
I guess I'm not sure if this is the right audience, or I suppose anyone could answer if they know, but. Since many of the cases involve Christian churches, is anyone aware of how, sort of going along with the idea of airing your dirty laundry, how the parties involved interpret scriptures talking about church disputes should not be taken to secular courts, disputes between believers should be decided by church authority?
By people who have been trained by our Strauss Institute of Dispute Resolution.
Does anyone have any thoughts as to how Christians who are parties to these cases see those scriptures? Or
Maybe what we could do with that question is have Jim and Lynn respond to that, since they are the lay people in the group and have been involved with churches that have probably wrestled with this issue. Lynn?
Well, before you do that, let me just add that in the research that I did find a Buddhist case. I did find several synagogue cases. So there are other cases out there besides the Christian cases, although those are the ones that we seem to be involved with right now. So this does seem to happen at a lot of different levels, but predominantly Christian, I would say.
And we do know at a practical level that many times, we only know it from anecdotal evidence, but we know that many times these disputes end up not going to the court because people in those churches ultimately take very seriously the admonition not to take this to court. And individually, you could just rattle off, and I can't even guess the percentage, but a very high percentage, that finally decides to get the people to work it out either through their larger denominational arbitration associations or larger ones like the Christian Conciliation Service or ecumenical ones, or calling in experts from other churches that they trust. It's very common, and it's that admonition that often leads, as a practical matter, to not taking it to court. But we have a couple people.
Can I just make Reverend Miller? I just want to call Reverend Miller to the stand because your story of the 7 congregations. So First Pres of Schenectady went its way, but many of these were resolved.
Sorry. Well, I just think, in general, we have tried not to go to court. I mean, it's the last resort, and I would say...
Reverend Miller, they are handing you the mic. I'm not sure you
I
need
would
it,
say
just
roughly 90% of the cases that involve Presbyterians are initiated by the congregation, not by the denomination.
Quite opposite to that. To my knowledge, almost without exception, the cases in the United States have been brought by the Episcopal Church of the diocese as opposed to the congregations. The litigant who brought the case to court has been the Episcopal Church. And with that, I just have to say that I believe that the reason for that, as I mentioned earlier, is there's no judicatory body within the Episcopal Church to resolve temporal issues such as this. There are canons and constitutions, parts of the Constitution to resolve the ecclesiastical issues. If a bishop or a priest misbehaves, there's an ecclesiastical court to take care of those, presentments, admonitions, etc. But there is no such body within the Episcopal Church to resolve those disputes. And so the Episcopal Church has been the person to sue.
I think we have one more response, or 2 more.
I just wanted to ask a clarifying to Ms. Moyer, and that is, would you also tie that, in your presentation you made a lot of comments about how you thought the Episcopal Church was not following Scripture. In fact, directly not. Do you think that part of the Episcopal Church's willingness to bring suit is because the Episcopal hierarchy does not take Paul seriously?
Yes.
And do we have somebody else?
But I have to say, not only did the Episcopal Church were the suer in the Diocese of Los Angeles, but they sued the individual vestry members, the volunteers. And not only did they sue them, but they sued them for punitive damages. Huge. And these people are still defendants in the case.
I think we have one other comment.
And a very brief
Then we'll
comment.
turn it back to our main moderator.
From my observation, the behavior goes across the spectrum. I've heard the view expressed that this is not a situation that's governed by Paul's letter to the church at Corinth because in fact, the dispute is not an intra-church dispute. It's between the church and apostasy. And obviously that's just one of many views, but I know that many of the same people who believe that if it were an intra-church dispute, then they shouldn't be leaving. So it's only something that's so egregious as to say, this is fundamental to what the church is that forces us to leave, that also causes them to say, we're willing to fight in court over the property.
And I gather that's the view on both sides in a lot of these. Each of them believe they're fighting as the true church against apostasy. Well, I've got some important announcements to make, but I also just wanted to make one further point before we go. Many of you have seen our brochure and heard mentioned the fact that we're here with the support of the Herbert and Elinor Nootbaar Institute, which I direct. And I just wanted to say a word about who Herbert and Elinor Nootbaar are. Herb Nootbaar turned 100 years of age just a few months ago, and he made his donation to Pepperdine for this institute. He's not a lawyer. He made his money in agriculture, but felt that this was an important endeavor. He is just a wonderful guy. When we dedicated the institute on his 99th birthday, he showed up and we gave him a chance to make remarks, and he said that prior to the dedication, he had been talking with his wife, and his wife said, well, what are you going to wear to the dedication? And Herb said, well, I think I'll wear my new suit. And she said, oh, your new suit, the one you got when we got married 25 years ago. And he said, yep. And he held up his hands for us to see his very nice-looking suit. The other thing is that when we celebrated his 100th birthday party just a couple of months ago, he got the mic and announced that that week he had passed his driver's exam. Word got around the DMV that there was a centenarian, is that the right term, who was taking his driver's test, and that he passed it with a mark of 100 and got a standing ovation from the DMV. When's the last time you saw the DMV workers give a standing ovation to anyone? Secondly, announcement, I've got good news. I've still got a few more volleyball tickets for those of you that are interested in the game at 7. CLE forms, I don't see Audrey here, so if you could leave them on the very back row on either end of the back row as you leave, we'll be sure that they're collected and that they get to the right place. We now get to partake in a wonderful reception. The reception was in part funded by the law firm of Taylor Porter from Baton Rouge, Louisiana, which handles some of these types of cases. You see the mention of them in your schedule. Lloyd Lunsford, you might raise your hand. Maybe we could give a hand to Lloyd Lunsford and his firm for that. The reception, the food is as you exit, turn left, and it's out in the main lobby. I encourage you to get your food and then walk outside. If you go outside, there's probably a beautiful sunset in progress. I think, and it would be well worth your while. We would have put the food out there, but that may attract bees. But anyway, grab your food, go outside, and spend as much time with us as you'd like. Thanks for your kind attention, and I notice now that Audrey is with us, and so you can drop off your forms with her. And my thanks to this panel. We can give them a hand, and to you for making it a great night.